Hello and welcome to Chapter 27 in Healthcare Supervision. We're talking about the supervisor and the law. This PowerPoint has a lot of information in it, and this chapter contains a lot of information as well. So I'm going to kind of highlight some of the things that I really want you to focus on in this chapter. And I'm going to give you some tips along the way to help you study for your exam. So we're going to start in the text on 452, talking about the legal guides for supervisory behavior. So in this chapter, we're going to cover significant areas of legislation that place requirements on our organizations and thus influence supervisory behavior. The four topics we're going to talk about are the National Labor Relations Act, and we're going to highlight its applicability to health institutions. We're going to talk about the wage and hour laws for the benefit of the supervisor's familiarity in dealing with rates of pay, hours of work, and related matters. We're going to talk about equal employment opportunity, encompassing consideration of several laws that prescribe organizational behavior in regard to interviewing, hiring, and making certain work assignments. And last, other legislation applicable to some aspects of the employment relationship. All right, so we're going to drop down to the section titled the National Labor Relations Act. This National Labor Relations Act of 1935, known as the Wagner Act, provided the basis for most labor law in the United States. But there was another law that kind of paved the way for that Wagner Act, and it's the lesser-known Norris-LaGuardia Act, passed in 1932. This act marked a significant change in public policy from suppression of union activity to significant encouragement of such activity. However, it did little to restrain employers in their conduct toward collective bargaining. The NLRA was amended significantly in 1947 by the Labor Management Relations Act, known otherwise as Taft-Hartley. It is Taft-Hartley to which we're primarily referring when speaking of aspects of union organizing. One can find numerous references to the NLRA that are actually references to this law as amended by Taft-Hartley. And so the Taft-Hartley Act provides the framework for modern labor law. So prior to 1975, not-for-profit hospitals were exempt from all provisions of Taft-Hartley. But in 1975, the Act was amended to remove the not-for-profit hospital exemption. Before that time, hospital employees were covered only in special subsections of the labor relations laws of various states. The Taft-Hartley amendments were passed over the objections of numerous hospitals and the American Hospital Association. Generally, hospitals wanted to see the inclusion of mandated cooling-off period after the expiration of a contract and before a strike could occur. However, what they received was mandated fact-finding prior to the end of a contract negotiation. Employees of public hospitals, those institutions operated by cities, counties, and other arms of government, continue to be exempt from Taft-Hartley. All right, so dropping down to the 1975 amendments. So the Taft-Hartley amendments affecting not-for-profit hospitals are summarized as below. These amendments remove the exemption for not-for-profit hospitals from the Act. Second, the healthcare institution is broadly defined to include any hospital, convalescent hospital, health maintenance organization, health clinic, nursing home, extended care facility, or other institution devoted to the care of the sick, infirm, or aged people. Third, the legal notification period for negotiations on collective bargaining contracts is set at 90 days. That is, a 90-day notice by either the employer or the labor organization is required for renewals or modifications of contracts, but all other industry, that's a 60-day notice. So healthcare got an extra 30 days. Fourth, the Federal Mediation and Conciliation Service must be notified 60 days prior to the termination or expiration of an existing contract. And again, healthcare gets an extra 30 days because in other industries, it's only 30. Fifth, The labor organization will be required to participate in the mediation process in both renewal and initial contract situations. No such requirement exists for other industries covered by the Act. So again, healthcare gets special privileges. Number 6. Written notice must be provided by the labor organization to the healthcare institution and to the Federal Mediation and Conciliation Service 10 days prior to engaging in any picketing, strike, or other concerted refusal to work. And there are no strike or picketing notice provisions in the Act for other industries. Number 7. Prior to the expiration of the notification periods on renewal and initial contracts, and at the discretion of the Director of the Federal Mediation and Conciliation Service, an impartial board of inquiry could be established to investigate any labor management dispute and make a written report of its findings as fact. This process is applied only when the Federal Mediation and Conciliation Service judges that an actual or threatened work stoppage could substantially interrupt the delivery of health care to the community involved. And again, there's no such privilege for other industries. Next, an employee of the healthcare institution who is a member of a recognized religion, body, or sect that has historically held conscientious objections to participation in or support of labor organizations will not be required to join or support financially such an organization as a condition of employment. This applies to healthcare institutions only as defined within the Act. And last, the 1975 amendments preempt all state labor laws previously applicable to non-governmental hospitals. Also, the amendments apply to healthcare institutions previously covered by the Act, such as proprietary hospitals and nursing homes, as well as to all of those institutions brought under federal law by the amendments to the Act. Now, the congressional intent of these amendments is below. So, Congress wished to avoid fragmentation of bargaining units in healthcare institutions with numerous small units working with and bargaining with the same institution. Congress wished to establish special priority attention in handling by the National Labor Relations Board of cases involving unfair labor practice charges and labor management disputes in healthcare institutions. Congress intended that it be possible that patients could be transferred from a struck or threatened institution to another institution and obtain limited assistance from other institutions without risking secondary strikes or boycotts against the assisting institution. And lastly, Congress wished to reaffirm the existing National Labor Relations Board definitions of supervisors among professional employees in the healthcare institution. Now, we talked about these bargaining units in a previous chapter. You actually listed these on a test. You won't have to do that this time. But if you remember those, they were your registered nurses, physicians, all other professionals, technical employees, skilled maintenance employees, business office clericals, security guards, and your all other non-professionals. So previously, units were determined on a case-by-case basis, and a hospital, especially one of fewer than 100 beds, stood a good chance of having to deal with only 2 or 3 unions at most. Present rules, however, mean that a hospital of any size could conceivably have to deal with 8 or more separate unions. So that's just bringing that up. Now, dropping down to our wage and hour laws. Let's talk about what it means to be exempt and a non-exempt employee. Of primary interest is the 1938 Fair Labor Standards Act, which is the federal wage and hour law, and as such the model for the wage and hour laws of many states. Occasional points that might not be covered by federal law may be covered by pertinent state laws. Generally, if the same points are covered by both state and federal laws, but differences exist, the more stringent legislation will apply. Sounds like a good true and false question. So, in essence, if there is a federal law and a state law, and the same points are covered in both laws. Whichever one is the strictest is the one you're going to go with. If it's federal and it's more strict, then you're going to go with federal. If it's state and it's more strict, you're going to go with state. So whatever the more stringent law is what you're going to go with. All right, moving on to our exempt employees. Prior to 1967, hospitals were exempt from the minimum wage and overtime requirements of the Fair Labor Standards Act. Since the amendment of 1967, however, minimum wage and overtime requirements have applied equally in hospitals and as in other industries. 3 types of employees remain exempt and are identified as follows. Now, these 3, you will do some matching on these 3. So know the details when we're talking about our executive, administrative, and professional employees. So let's talk about executive first. An executive employee must generally spend 50% or more of the time in direct management of an enterprise or an organization subunit such as a department. In addition, an executive employee must direct the activities of 2 or more persons. The executive definition may also require that a person possess the authority to hire and fire or so recommended, possess discretionary powers rather than being assigned largely routine work, and from work week to work week, spend no more than 40% of the time on non-managerial work. All right, let's move down to our administrative employees. An administrative employee must spend 50% or more of the time on office or non-manual work related in some way to policy, general business, patient care, or people in general, and must be required to exercise discretion and independent judgment. Other tests of the administrative classification may involve assisting executive or administrative personnel, handling special assignments with only general supervision, working in a position requiring special training, experience, or knowledge, and spending not more than 40% of the time on non-administrative work. Now, our third category of exempt employees is the professional. Professionals in healthcare institutions, some of our examples are chemists, registered nurse, pharmacists, physicians, are so classified by virtue of spending 50% or more of the time doing work that requires advanced, specialized knowledge or is original or creative in nature. The definition may also require that the professional be consistently required to exercise discretion and independent judgment, be employed at intellectual and varied work, and be engaged in non-professional activities not more than 20% of the time. The FLSA specifies the minimum salary that executive, administrative, and professional personnel must be paid. The single exception concerning healthcare personnel applies to licensed medical practitioners and interns and residents. They are subject to no minimum salary requirements. Arguments based on the applicability of a particular non-exempt definition are generally decided on the basis of the percentage of time spent on various activities. The time test applies on a work week to work week basis. So you can read through the new exempt minimum salary under consideration, and then you can read about the minimum wage issues. But we're going to move on to when exempt is not exempt. So there's something of a trap that some organizations have fallen into because the insufficient attention was given to the definition of exempt, specifically the definitions of executive, administrative, and professional. In a typical instance, a highly placed secretary is retitled to administrative assistant or some such title, is given a pay increase to or just above the minimum exempt salary, and is designated as salaried. This person continues to function as previously, pursuing the duties that one might expect of an administrative secretary, and in doing so frequently works more than 8 hours in a day. The boss is happy. Even the administrative assistant may be happy, and all is well. That is, all is well until someone complains to the Department of Labor that people are being denied overtime pay, or until the Department of Labor selects the organization for random audit of overtime practices. If an individual whose hours are audited does not meet the true definition of exempt in terms of the proportion of time spent on true executive or administrative duties, the individual will be declared non-exempt rather than exempt, and the Department of Labor auditor will call for overtime pay. If time records are not available, lost overtime pay is determined based on estimates of overtime hours worked. If it's decided that there was no intent to cheat the employee, the Department of Labor will order imputed back pay for a 2-year period, overtime pay for 2 years. If the Department of Labor auditor decides that the employer was deliberately trying to avoid overtime payment, then 3 years of imputed back overtime pay will be ordered. The lesson is, of course, for any employer to be absolutely certain the legal definition of exempt employee applies before so classifying any individual as exempt. So, what are non-exempt employees? Well, these are your hourly employees. All employees who do not fall under the executive, administrative, or professional category are considered non-exempt employees. They must be paid at least the prevailing legal minimum wage for each hour worked in a work week, and they must be paid at a rate of 1.5 times the regular rate for all overtime hours. In addition, they must be given equal pay for equal work unless there are legitimate factors that justify the establishment of different rates, and gender is not a legitimate factor. The organization is required to keep detailed record of hours worked and wages paid. There are a few well-defined exceptions to the payment of a legal minimum wage. Special regulations allow the payment of a lower rate to students, learners, and apprentices. Employment of such persons is also subject to additional requirements and restrictions. All right, so we're going to go over to overtime compensation. All right, so the FLSA defines the work week as a fixed recurring period of 168 hours. That's 7 consecutive 24-hour periods. So 24 times 7 is 168. These 24-hour periods need not be calendar days, and the 7 periods together need not be a calendar week. For instance, work weeks beginning and ending at midnight Friday or midnight Sunday are not uncommon. North Mississippi Medical Center, the work week begins at 12 a.m. Sunday and ends at 11:59 p.m. Sunday evening. So that's the work week at North Mississippi Medical Center. The work week may be changed, and many organizations have done so to facilitate payroll accounting, but it cannot be changed in such a way to avoid payment of overtime. So if you were to try to change it in the middle of a 2-week pay period, you can't do that. All right, so let's talk about the time and a half, how this applies to the different kinds of schedules that an employee may work. So the FLSA requires payment of 1.5 times a worker's regular rate for all overtime hours. Now, overtime hours are defined as those hours in excess of 40 hours in a 7-day work week, where the usual 7-day work week is used, or you have what's called an 880. The employee can work 8 hours per day or 80 hours per 14-day period when the use of the 14-day period has been approved and posted. So what that means is if you're a regular employee and you just work a weekly schedule, then you should work 40 hours within that 7-day time frame. So if it starts at noon on or 12 a.m. on Monday, and I said that wrong earlier, but it begins 12 a.m. on Monday and goes until 11:59 p.m. the next Sunday. So that's your 7 days. If you work 40 hours within that work week, then you don't get any overtime. But if you work 42 hours, then you will get the 2 hours of overtime. Now, let's talk about the 880 and how this works. In an 880, you cannot work more than 8 hours in a day without getting overtime. Okay? So what this means is if I'm on an 880 schedule, and some of the transcriptionists over at North Mississippi are on an 880 schedule because they work weekends. And the benefit of doing that is they can be flexible in the days they take off, Monday through Friday, when they have to work the weekend. So let me use this as an example. If one transcriptionist is working a 40-hour week, and that's what they always do, then Monday through Sunday they have to work 40 hours. They have to. So they're going to work Saturday and Sunday. Well, they have to take off those 2 days to make up for Saturday and Sunday prior to Saturday and Sunday, because Sunday ends the week. So they might have to work Monday through Wednesday, take off Thursday, Friday, work Saturday, Sunday. That's their work week, 7 days. You have to work 40 hours in 7 days. But on an 880, you don't have to work 40 hours in 1 week. You could work 32 hours in 1 week and work 48 hours the next, as long as you got the 80 hours within that 14-day period. So let's say the transcriptionist works Monday through Thursday. They're off Friday. They work Saturday, Sunday, and Monday. Then they can be off Tuesday and work Wednesday through Friday. And so they've still got their 10 days in, which times 8 is 80 hours. And they're not getting any overtime, and they have a little bit of flexibility. But again, the caveat is, if you work more than 8 hours, you're going to get overtime in that 880 schedule. So let's look at Exhibit 27.1 and 27.2 on page 459. These are our 880 illustrations. So we have 14 days. That's a pay period. So that's 2 work weeks. But again, work week doesn't necessarily apply here because you're looking at 14 days. So in our first example, day 1, day 2, they work 8 hours. Day 3, they work 5. Day 4, they work 10. Day 5, 8. Let's say 6 and 7 are a Saturday and Sunday, so they're off for the weekend. Then on Monday, on the 8th day, they work 9 hours. And then Tuesday, Wednesday, Thursday, and Friday, they work 8 hours. And then they're off for the weekend. So how many overtime hours does this employee get on this 880 schedule? Well, it's 3. Because on the 4th day, they work 10 hours. So that's 2 hours over the 8. So that's automatic 2 hours of overtime. And then on the 8th day, they work 9 hours. That's 1 hour over the 8 hours. So that's 2 plus 1, 3 hours of overtime. Now, it doesn't matter that they only work 3 hours or only work 5 hours on the 3rd day. You can work under 8. Now, let's say that employee wanted to make up those 3 hours on a Saturday. So let's change this example. On Exhibit 27.1, we're going to pretend that this looks like day 1, day 2 are 8. Day 3 is going to remain at 5. Day 4 is going to change to 8. Day 5 is going to stay 8. But let's say on day 6, on that Saturday, they wanted to make up the 3 hours they missed on that 3rd day, and they worked 3 hours on day 6. If they continue that pattern and we left that 9 hours on day 8, then we're only looking at 1 overtime hour. It's everything over 8 hours. So in our Exhibit 27.2, we have 1 day within this 14-day time frame that they worked over 8 hours, and that's on day 12. So in this example, we have 2 overtime hours. Okay? So, dropping down on 459 to the very last paragraph on that page. The FLSA also specifies that only hours actually worked need to be counted toward determining overtime. That is, the institution is not required to count non-worked time, such as vacation days, sick leave, holidays, and personal time as part of the 80 hours. So if you're going to get overtime, then you've got to actually work that time. So if I just took, 8 hours of vacation, but I worked, and we're going back to a 40-day, a 40-hour-a-week thing. Let's say I take off on Monday, and I use 8 hours of vacation, and then I work, 40 hours because I ended up working on Sunday. Then I can either take my vacation back, but you can't include that can't be counted towards determining overtime if you take vacation. All right, moving over to 460 and talking about the regular rate. The so-called regular rate, referred to in the FLSA, includes the scheduled hourly rate plus on-call pay, call-in pay, and shift differential. And we have our example over on page 461 in Exhibit 27.3. So, rates paid, you've got a base, a shift differential, a call-in rate, and an on-call rate. And so now we've got our calculation. So the employee worked 50 hours and they had 4 hours of on-call time. So in our calculation, we have 15, which is the base rate, times 46 hours because they worked 50, but 4 of those were on call. So 50 minus 4 is 46. So that gives us the $690. And then we have our on call. So they were on call 4 hours. That's our shift differential. So we have our shift differential, $1 times 46 hours, which is $46. And then we have call in for $75. And then they have the $25 for on call. So those are just base rates. Add that all together, and then you divide it by 50. So we get 836 divided by 50. So their regular rate was $16.72 for that time frame, even though their base rate was $15. So your regular rate is the hourly rate plus on-call pay plus call-in pay and shift differential. So that's your regular rate. So we're going to kind of go through that paragraph just to make sure that sinks in, or that section. Assume the employee in the example is paid overtime under the 7-day, 40-hour work week. The employee receives the following amounts. So we talked about our hourly rate of 15, the flat rate of 25 for on-call, 75 for 4 hours work on-call, and $1 per hour shift differential. Assume the employee actually worked a total of 50 hours, including the 4 hours, and that shift differential did not apply to the hours of on-call time. So that's why we did a shift differential of 46 hours. It only applies to the worked time. Because the employee worked a total of 50 hours, we divide the total of 836 by 50 to arrive at the regular rate of $16.72. Therefore, 10 hours of excess time the employee must be paid, and 1/2 this regular rate. So for 10 hours, the employee will receive an extra $8.36 per hour, which is our overtime premium. So $8.36 is half of $16.72. And so the total owed to the employee in the example is $919.60. So we got our regular rate, and then we took our base earnings of the $8.36, and then we took our overtime, half of the $16.72 times 10, because again, they worked 50 hours. That's 10 hours of overtime. And so you multiply the base rate, or the regular rate, times 1/2 to get the half, 836, and then multiply that times 10, so to get 8360, and then you add that to the 836 to get 919.60. So just pay attention to that example. No, I'm not going to give you any math problems on the test, so don't worry about that. All right, moving over to the equal employment opportunity on 460. So as amended by the Equal Employment Opportunity Act of 1972, and again, we're talking about Title 7 of the Civil Rights Act of 1964, this legislation prohibits discrimination because of race, color, religion, sex, or national origin in any term, condition, or privilege of employment. The Equal Opportunity Act of 1972 greatly strengthened the powers and expanded the jurisdiction of the Equal Employment Opportunity Commission in enforcement of this law. Title VII was amended to cover all private employers of 15 or more persons, all educational institutions, public as well as private, state and local governments, public and private employment agencies, labor unions with 15 or more members, and joint labor management committees for apprenticeship and training. The EEOC investigates job discrimination complaints, and when it finds reasonable cause that the charges are justified, it attempts, through conciliation, to reach agreement by eliminating all aspects of discrimination revealed by the investigation. If conciliation fails, the 1972 amendments give the EEOC the power to go directly to the court to enforce the law. Among other important provisions, the 1972 Act also provides that discrimination charges may be filed by organizations on behalf of aggrieved individuals, as well as by employees and job applicants themselves. Applicants may also go to court directly to sue employers for alleged discrimination. All right, so let's talk about the Equal Pay Act of 1963. The Equal Pay Act of 1963 requires all employers subject to the FLSA to provide equal pay for men and women performing similar work. So just know that the Equal Pay Act of 1963 requires all employers subject to the FLSA to provide equal pay for men and women performing similar work. And in 1972, coverage of this act was extended beyond employees covered by the FLSA to an estimated 15 million additional executive, administrative, and professional employees, and to outside salespeople. All right, our next one, age discrimination. The Age Discrimination in Employment Act of 1967, addressing age discrimination in essentially all aspects of employment. So this, as self-titled, addresses age discrimination in all aspects of employment. It has been amended a number of times since its initial passage. It applies to private employers and state and local governments having 20 or more employees, and to labor unions having at least 25 members. The original act prohibited such employers from discriminating against persons in the 40 to 70-year-old range in any area of employment because of age. The Age Discrimination in Employment Amendments Act of 1986, effective for most employers on January 1, 1987, removed the age 70 limitation on ADEA protection. The employer can either place an age limit on candidates for employment, nor establish a mandatory retirement age for most employees. Now, our exception there, if we covered in a chapter earlier, were those positions that were bona fide occupational qualifications. So you can place an age limit on those. All right, moving over to, and it's not in our slide, but we're going to talk about it, the Older Workers Benefit Protection Act of 1990. The Older Workers Benefit Protection Act is essentially another amendment to the ADEA, clarifying the authority of the ADEA relative to employee benefits. Although it required equal benefits for all workers, following a number of legal decisions, the ADEA allowed reductions in benefits for older workers in instances where added costs were involved. The Older Workers Benefit Protection Act removed the option for the employer to justify lower benefits for older workers and required that any waivers or releases of age discrimination must be voluntary, part of a written agreement between employer and employee. In effect, this law says that an employer cannot unilaterally provide a reduced benefit to an employee on the basis of age. So remember that. This law says an employer cannot unilaterally provide a reduced benefit to an employee. It has to be an agreement between the employer and the employee. So really what I'm expecting from this test is we're going to learn key points about each one of these acts. So going back to our Civil Rights Act on page 460, know that it prohibits discrimination because of race, color, religion, sex, or national origin. The Equal Pay Act has to provide equal pay for men and women performing similar work. Or age discrimination. Again, it addresses age discrimination in all aspects of employment. Older workers says that they cannot unilaterally provide a reduced benefit to an employee based on age. So you're wanting to know the highlights of each of these different laws because we're probably going to do some matching on this. All right, Title VI of the Civil Rights Act of 1964. See, we already talked about Title VII. Now we're going back to Title VI. This prohibited discrimination based on race, color, or national origin in all programs or activities receiving federal financial aid. Employment discrimination is prohibited because a primary purpose of federal assistance is the provision of employment, such as apprenticeship, training, work study, or similar programs. Revised guidelines adopted in 1973 by 25 federal agencies prohibit discriminatory employment practices in all programs if such practices cause discrimination in services provided to program beneficiaries. So again, Civil Rights Act of 1964 prohibits discrimination based on race, color, or national origin. So just remember that for that one. Doesn't worry about the year. All right, moving over to the ADA, the Americans with Disabilities Act of 1990. This was largely effective in 1992. It affirmed the rights of persons with disabilities to equal access to employment, services and facilities available to the public, transportation, and telecommunications. Covered disabilities are defined in the law. So this one again is another self-named act. It's protecting Americans with disabilities, and it is ensuring that they have equal access to employment, services, and facilities available to the public, and that's whether it's private or public, transportation, and telecommunications. The ADA requires employers to provide reasonable accommodation for disabled individuals who are capable of performing the essential functions of the position for which they apply. This may include altering physical facilities to make them usable by individuals with disabilities, restructuring jobs around their essential functions, and altering or eliminating non-essential activities so that the disabled persons can perform the work. So again, American with Disabilities, it makes sure that they have equal access to employment, services, and facilities, transportation, and telecommunications. All right, moving over on 464 to talk about the Civil Rights Act of 1991. So this was essentially passed to reverse several Supreme Court decisions that had the effect of weakening existing laws. It provided for the most extensive modification of Title VII, which is of the Civil Rights Act, in more than 20 years. This newer law relies on jury trials along with statutorily limited compensatory and punitive damages as the basic litigation scenario under Title VII of the Civil Rights Act and the American with Disabilities Act. This act introduces jury trials into employment law to determine liability and compensatory and punitive damages for violations that are found to constitute intentional discrimination. So the Civil Rights Act of 1991 reversed several Supreme Court decisions, and it relies on jury trials into employment law to determine liability and compensatory and punitive damages for violations that are found. So the net effect of this legislation on employers is to increase the likelihood of legal action and increase legal costs associated with trials because potential plaintiffs and their attorneys are attracted by the prospect of damage awards and attorney fees. All right, Family Medical Leave Act of 1993. This one's kind of easy too. Again, self-explanatory. This provides up to 12 weeks of unpaid leave if you have worked at least 1 year and 1,250 hours. So you can take 12 weeks of unpaid leave. Here are your qualifying reasons: for the birth of the employee's child or the care of that child up to 12 months of age, for the placement of a child with the employee for adoption or foster care, for the employee to care for a spouse, child, or parent having a serious health condition, and for the employee's own serious health condition involving the employee's inability to perform the essential functions of the job. Now, you can take this 12 weeks of unpaid leave, and by law, you can return to your original position, and if for some reason they could not give you your original position, then you have to be able to come back to a fully equivalent position in terms of pay and benefits and overall working conditions. So again, family medical leave, you're able to take up to 12 weeks of unpaid leave without the loss of employment, and we listed off why. If you're giving birth or adopting a child, caring for a spouse, child, or parent with a serious health condition, or you have your own serious health condition. All right, moving over to state and local laws. We're just going to mention this. Many state and local government laws prohibit employment discrimination. When the EEOC receives discrimination charges, it defers them for a limited time to various state and local agencies having comparable jurisdiction and enforcement status. Determination of which agencies meet this deferral standard is a continuing process. These agencies' procedures and their requirements for affirmative action vary, but if satisfactory remedies are not achieved, the charges will revert to the EEOC for resolution. All right, so dropping down to the National Labor Relations Act and related laws. So we're going to cover all these different laws, and again, you're going to need to know the key points of these laws. So discrimination on the basis of race, religion, or national origin may violate rights arising under these laws. It may be unlawful for employers to participate with unions in the commission of discriminatory practices unlawful under these acts, or to practice discrimination in a way that gives rise to racial or other divisions among employees to the detriment of organized union activity. It may also be unlawful for unions to exclude individuals from union membership, thereby causing them to lose job opportunities, to discriminate in the representation of members or non-members in collective bargaining or in the processing of grievances, or to cause or attempt to cause employers to enter into discriminatory agreements or otherwise discriminate against union members or non-members. So, our first one down here. Title 9. Have to think about my Roman numerals here for a minute. Title IX, Education Amendments Act of 1972. So in addition to extending coverage of the Equal Pay Act, this law prohibits discrimination on the basis of sex against employees or students of any educational institution receiving federal financial aid. So education amendments, this law prohibits discrimination on the basis of sex against employees or students of any educational institution. So education amendments of 1972 is going to be law prohibits discrimination on the basis of sex against employees or students. All right, the Rehab Act of 1973. The Rehab Act of 1973, as amended the following year, requires affected employers to maintain affirmative action programs to ensure the hiring and promotion of quality handicapped persons. So that's what you want to remember. The Rehab Act requires affected employers to maintain affirmative action programs to ensure the hiring and promotion of qualified handicapped persons. All right, the Vietnam Era Veterans Readjustment Assistance Act of 1974. Again, this is going to be another self-entitled one. So it extends the protection of affirmative action to disabled veterans and veterans of the Vietnam period employed by contractors holding federal contracts of $10,000 or more. So again, self-name, veterans or veterans of the Vietnam period. All right, we're going to skip other laws addressing discrimination, and we're going to go over to our other pertinent legislation, and we're going to start with COBRA, the Consolidated Omnibus Budget Reconciliation Act of 1985. Now, what you need to know about this: COBRA gave some employees and beneficiaries the right to continue their insurance coverage under an employer-sponsored group health plan for a limited time after certain events that could cause them to lose coverage, such as termination of employment. So, depending on the form of termination, employees or beneficiaries can continue coverage at their own expense for a period of either 18 or 36 months. Now, I'll tell you, COBRA is expensive. Very, very expensive. But it is available. So if you were going to, let's just say you're going to retire before you're eligible to draw your retirement or whatever, then COBRA is an option for you, especially if you're not Medicare age. COBRA is an option for you to continue with the insurance you had at your job, but you're going to pay an arm and a leg for it. So that's what COBRA is. So just remember, COBRA gave employees and beneficiaries the right to continue their coverage under an employee-sponsored group health plan for a limited time after the occurrence of certain events that would otherwise cause loss of coverage, usually termination of employment. So that's what you need to remember for COBRA. Lets them have their insurance coverage for 18 to 36 months after their position has been terminated. All right, the Employee Polygraph Protection Act of 1988. This legislation bars employees from using a polygraph, which is a lie detector test, for pre-employment screening or during the course of employment. Thank God for that. So, again, this does not allow an employer to ever give an employee a lie detector test. Sounds crazy, huh? So just know that. Next one, the Employee Retirement and Income Security Act. This is ERISA. This is a big one. This law established minimum standards for pension plans in private industry and provided extensive rules concerning the federal income tax effects of transactions having to do with employee benefit plans. It was enacted to protect the interest of the benefit plan participants and their beneficiaries. Responsibility for its interpretation and enforcement is divided among the Department of Labor, the Department of the Treasury, which is the IRS, and the Pension Benefit Guarantee Corporation. So again, the biggest thing about ERISA is that it established minimum standards for pension plans in private industry and provided extensive rules concerning the federal income tax effects of transactions having to do with the employee benefit plans. All right, moving on to HIPAA, Health Insurance Portability and Accountability Act of 1996. So HIPAA has had and continues to have significant effects on a great many healthcare provider organizations. Ironically, this law's far-reaching effects have little or nothing to do with health insurance portability and accountability of the title. We're not going to cover Chapter 28. That's what that whole chapter is about, so we know what HIPAA is. But in the beginning of time, Health Insurance Portability and Accountability Act meant that you could leave a job or transfer your insurance to other places. So that's essentially what that law was. That's what it was originally for. It morphed from there. All right, the Immigration Reform and Control Act of 1986. This law, also known as the Simpson-Mazzoli Act, requires employers to verify that all newly hired employees provide valid documentation confirming their identity and legal authorization to accept employment in the United States. Another thing you need to know, is that the Employment Eligibility Verification Form, the I-9 form, has to be completed for every new employee within 3 days of starting work. Okay? So the Simpson-Mazzoli Act, also known as the Immigration Reform and Control Act of 1986, requires employers to verify that all newly hired employees basically have the legal right and can confirm their identity to work here in the U.S. And the I-9 has to be completed within 3 days of starting that work. Okay? All right, moving over to 468 to OSHA, the Occupational Safety and Health Act of 1971. This one, not a lot to know, but it was enacted to ensure that employers provided employees an environment free from recognized hazards such as exposure to toxic chemicals, excessive noise level, mechanical dangers, heat or cold stress, and unsanitary conditions. So just remember, OSHA is about your working conditions. All right, so moving on to our last slide. We've moved past all of our acts and laws that you need to be familiar with, and we're moving into sexual harassment. So because of its prominence in today's society, a few comments on the subject of sexual harassment are in order. The number of sexual harassment complaints filed with the EEOC and various state agencies continues to increase, as does the number of employers involved and the extent of monetary penalties. Sexual harassment continues to be one of the two more prominent causes of legal complaints against employers. The other is age discrimination. Prominent sexual harassment complaints receiving frequent media coverage have undoubtedly been a factor in encouraging some persons to give voice to complaints they might otherwise have kept silent about. The legal basis for defining and addressing sexual harassment has been in place for some time. Sexual harassment is in fact a form of sex discrimination under Title VII of the Civil Rights Act of 1964. Sexual harassment consists of unwelcome sexual advances, requests for sexual favors, or other conduct of a sexual nature if submission is either an actual or implied condition of employment. Submission or rejection is used as a basis for making employment-related decisions, or the conduct interferes with work performance or creates an offensive work environment. A key concern in the foregoing lies in the word unwelcome. Conduct is considered unwelcome if the employee neither solicited nor invited it and regarded it as undesirable or offensive. To a certain extent, whether a particular occurrence is or is not sexual harassment may largely depend on the perception of the victim. Sexual harassment can take on a number of forms: sexually explicit pictures, calendars, or other materials, offensive sexually related language, including sexual humor, or other sexual conduct that creates a hostile environment, sexually explicit behavior, indecent exposure, sexual propositions or intimidation, offensive touching, and participation in or the observation of sexual activity are all examples of sexual harassment. So also is something as seemingly innocent as repeatedly asking a coworker or subordinate for a date after having been turned down. This latter situation adds to the dimension of repetition to some harassing behavior. Asking a time or two might be considered reasonable, but asking repeatedly, especially having been turned down, may be considered harassing. Sexual harassment is not limited to strictly the workplace. Much does, of course, occur in the workplace, but it is also sexual harassment if it occurs off premises at employer-sponsored social events, and even off premises at private sites if it involves people who have an employment relationship with each other. In addition to involving employees, sexual harassment can involve visitors, vendors, patients, and other potential perpetrators or victims. All right, dropping down to the very last section here. The foregoing barely scratches the surface of the collection of laws, rules, and regulations in which healthcare organizations must comply. looking only at a number of areas that are likely to be of concern to healthcare supervisors. There are many additional regulations bearing on finance and reimbursement, quality of care, provision of services, medical practice, nursing practice, and many other aspects of organized healthcare activity. The recent 3 to 4 decades have seen a dramatic increase in the amount of new and expanded federal legislation affecting conditions of employment. Primarily among the day-to-day concerns of the Human Resources Department, many of these changes will generally not be immediately visible to the individual supervisor. However, you're likely to see many of the effects of this legislation as regularly occurring change in the features and facets of employee benefit programs. Many regulatory requirements vary from state to state, but overall they add up to a measure of external control that makes healthcare the most heavily regulated industry in the country. Who needs more rules? Certainly not us. Remember, however, that as supervisors we're also employees, and that the protection afforded our employees under legislation addressing such topics as equal pay and age discrimination also extends to us. As supervisors, we should be willing to recognize that certain laws represent a well-defined part of our boundaries, those outside limits within which we must learn to work in fulfilling our responsibilities. Okay, so again, to cover this chapter, because there is a lot of information, I know it's going to be difficult to study. What you're going to do for your test is there will be the dreaded true and false. There will be a few, not many, no more than 5 probably. But what you will need to know is something about each one of these acts. So know the details of these acts. Know the key components of these acts. Probably not going to have more than one question about each one of the acts. But, you may match them, or they may be multiple choice. Not sure yet. Now, the exempt employees, you will match those. The details describing the executive, administrative, and professional employees. You need to know all of those details because you could have, 2 or 3 matches for each one of those. So just know those. Also, you need to understand, again, the overtime compensation, how the work week is defined, how it works. I may give you a graph like the Exhibit 27.1 and 27.2 on 459. I may give you one of those and tell you to tell me how many overtime hours a person's going to be paid based on how many hours they work. So be familiar with how to do that. And then again, know that regular rate. I'm not going to give you any math problems on this test. But under this equal opportunity or equal employment opportunity starting on 460, those are going to be the ones that you need to know the details on. So again, I've listed off a bunch of those for you so that you would know the highlights for each one of those. And again, some of them are self-labeled. Veterans, American with Disabilities, the Retirement and Income Security Act, ERISA, Polygraph Protection Act. Some of these are just you're going to know by the name, but some of the other ones, you're going to have to study. So be sure to study each one of these. Be familiar with the high points. Again, like I said, I listed a lot of them off in the lecture, so just be familiar with those. And again, check through that PowerPoint. PowerPoint's got a lot of information on it as well that will help you study for the test. So good luck. Happy studying.